The Fair Labor Standards Act establishes standards for wages and work hours. But because the statute doesn't define work, courts have disagreed about whether time related to putting on and taking off required protective gear is work for which employees must be paid. In IBP versus Alvarez, the Supreme Court weighed in. IBP operated a meat processing plant. Its production workers wore ordinary safety gear such as hard hats and safety goggles. Many workers also had to wear specialized safety gear to protect them from knives and other sharp equipment. The company required employees to store their safety gear in company locker rooms, where they also put on and took off the gear. Employees were paid based on the time spent processing meat, beginning with the first piece of meat and ending with the last. The employees, including Alvarez, filed a class action against the company under the Labor Standards Act to recover compensation for the time spent donning and doffing, or putting on and taking off, their safety gear and walking between the locker rooms and the production floor at the beginning and end of their shifts. The district court ruled for Alvarez, finding that donning and doffing specialized protective gear was integral and indispensable to the work performed by the employees who wore it. IBP didn't challenge the district court's conclusion that its employees were entitled to compensation for time spent donning and doffing specialized protective gear, but it appealed the holding that employees should be paid for time spent walking between the locker rooms and the production floor. The Ninth Circuit affirmed. The United States Supreme Court granted cert.